Hi, I'm Carleen Sangwan. I'm your sister-in-law, and the word of the day is, or the words of the day are, witness summons. A witness summons. You might be saying to yourself, well, Carleen, you don't practice litigation, and a witness summons sounds like some kind of court matter. Well, you're right and you're wrong. You're right in that I don't litigation, and you're right in that it's a court matter, but it is relevant to the area of law that I practice. It has to do with estates, and in particular a will. So if, for example, you have some person, a random person, who is known to be in possession of the will of somebody who has died and has taken that will and is refusing to give up the will to either the executor or to the beneficiaries to have the will probated, you can apply, or the beneficiaries can apply, or the executor can apply to the Supreme Court for a witness summons, which is issued, served on the person holding the will. And it says it's either you hand over the will or you give us an affidavit saying that you don't have the will. And if you don't hand over the will, or you don't issue file an affidavit, you don't have the will, then you are in contempt of court, and proceedings, legal proceedings, can be taken out against you. So very, very useful tool, because we have lots of situations like that where somebody will say it's known that they have the will, they don't want to give up the will, because the will, if they give up the will, that they're going to lose out somehow a gift in the estate. They may be entitled to it in intestacy, or they have control of it, but if the will is probated, all of that is taken away from them. So it's their benefit to hide the will. But they may also not want to destroy the will, because that could get them into even deeper trouble. So because everybody knows that they have the will, so this is a way to compel them to produce the will. And if they file an affidavit to say they don't know where, they don't have the will, then if a copy of the will exists, that is evidence, sufficient evidence for the beneficiaries then to apply for a grant of letters of administration with the copy of the will annexed, and to apply to the court to have that copy admitted to probate. So it's a